Australia. Today, we're very lucky to have with us Lee Carroll from Johnson Winter Slattery and Christopher Boog from Schellenberg Widmer. They're going to be discussing arbitrator disclosures and the application of one rule by many rulers. So very much looking forward to hearing your conversation, Chris and Lee. And as always, we'll have some questions at the end. And so we'll open up the floor in due course. Many thanks, and over to you.
Well, thanks very much, Emily, and hi, everyone. It's a pleasure to be with you here today, even though it's only virtually. The topic that Lee and I thought we'd discuss today was triggered by several events. One of them is some recent case law from different jurisdictions, and we'll go into that in a bit more detail as an introduction. But then also, of course, the latest revision of the ICC rules, which are going to enter into force next Monday. So we're going to be addressing those as regards disclosure obligations as well. And I think from those two things, a genuine question of what rules actually apply to disclosure and international arbitration these days. Is there a consensus among us all what those rules are? Or does it rather depend which institution is involved and which courts might be seized with a challenge to an arbitrator, or then even further down the road with the request for enforcement of an arbitral award or not? And then I guess the follow-up question from that, if we do think that we have more or less similar rules that apply to all of us, are these rules applied consistently by arbitrators, institutions, and courts? So to set the scene briefly before I move over to Lee, the recent cases that triggered this discussion was cases that you may have heard of because they were reported, at least some of them were reported quite broadly in the press. One was a decision by the Delhi High Court from April 2026, where the Delhi High Court refused to enforce an ICC award that was issued in Singapore based on a non-disclosure of an appointment by the chairman of the arbitral tribunal that he had been appointed by the chairman of one of the parties in an entirely unrelated arbitration that had taken place 4 years earlier. Interestingly, that case went to the ICC court. The ICC court did not remove the arbitrator. The arbitrator said before the ICC court, well, I only found out that this person was the chairman of the claimant in this case later on. I checked the IBA guidelines, and based on the IBA guidelines, because it was more than 3 years back, I decided that I did not have to make a disclosure. The Indian courts were not having that. The Indian courts very clearly said you should have disclosed, and because you didn't disclose, that fact alone means that the award cannot be enforced. The second case was also a very recent case from earlier in 2026. It's an investment treaty case involving Lufthansa and Venezuela, where Kai Hober was challenged in the investment treaty case on the basis that he was arguing an issue in a setting aside proceeding in Sweden, which arguably was the same or a similar issue that was being dealt with in the arbitration between Lufthansa and Venezuela, where he was sitting as arbitrator. And the interesting thing about that case is it was decided by the Secretary General of the PCA as the appointing authority deciding on the challenge. And they decided that there was no issue conflict in the case at hand, but nevertheless decided to remove the arbitrator because he had failed to disclose that there may have been issues that may have potentially constituted an issue conflict, but didn't actually constitute an issue conflict in the case at hand. And then the third and final case I wanted to mention is Global Gas Refinery Limited versus Shell Petroleum Development Company. That's an interesting case because it's a case from Nigeria that related to a actually domestic Nigerian case. So both parties, even the Shell party, was a Nigerian company. And the title of the reporting of that case, I don't have access to the case, but the press report part of the title is the Lagos High Court says that when challenged, an arbitrator should resign. So that's already, I guess, questionable, at least to some of us. But what had happened in that case was also that the arbitrator was faced with something that was arguably quite clearly on the green list of the IBA guidelines on conflicts of interest, did not make a disclosure, was challenged before the ICC court. The ICC court said there's no conflict, so did not remove the arbitrator. But again, the Lagos court saw it very differently, and set aside the award because it said this should have been disclosed. Anything needs to be disclosed, and if not disclosed, that's a ground for challenge. And as I said, even went further and said when challenged, what you need to do kind of automatically, it seems, is to resign. So where does this leave us, right? Seemingly we have at least had in the past relatively clear rules, the IBA guidelines on conflict of interest. They have a traffic light system. They also have a rule that says when in doubt, you should disclose, but it's very clearly stated that anything on the green list, there is no doubt and you don't have to disclose. So you have relatively clear guidelines. Obviously, if you're not sure whether something's on the green or on the orange list, then you might decide in favor of disclosure. But is this what institutions, courts, and other decision makers deciding over challenges or failures to disclose are really applying? And is it what we as arbitrators are really practicing today? I think some courts, yes, some courts, no. Some decision makers, yes, some decision makers, no. And some institutions, yes. And I think some institutions, clearly not. And with that, I hand over to Lee, who's going to give us a bit of insight on the ICC, the new ICC system.
Thanks, Chris. So having regard to this divergence of application, I'm looking at the new ICC proposed rules to see whether it adds to or subtracts from the confusion, if you like. So generally speaking, the major institutions all require disclosure of circumstances that may give rise to justifiable doubts as to an arbitrator's impartiality or independence. The new ICC rules, they maintain the same disclosure obligation as in the existing rules, but there are two clarifications, both of which were in the note to the 2021 rules, but have been elevated to these 2026 rules. The first is a clarification that the arbitrator, when in doubt, should disclose. And as Chris said, that is also in the IBA guidelines. The second clarification is that disclosure alone is not evidence of a conflict or a lack of independence or impartiality. And that's also in the IBA guidelines. In addition to those two clarifications, there's a new party engagement piece, if you like. So a new disclosure-related obligation for the parties. Each party must provide the Secretariat with a list of persons or entities that it believes the arbitrators should consider and why. So Chris and I might just have a little chat about these rules and see what we think of them. And then, we'll welcome your views as well. So first, the clarification that an arbitrator, when in doubt, should disclose. I wonder if it's a stricter standard to the IBA guidelines, and whether the institution requires green list circumstances to now be disclosed. Chris, what are your views on this clarification?
I agree. I mean, as I said, the IBA guidelines have a similar rule, right? It also says in the IBA guidelines somewhere, when in doubt, you should err on the side of caution and disclose. I think the big difference for me between the IBA guidelines and the ICC rules is the IBA guidelines give you very clear guidance when there cannot ever be any doubts, which is the green list, or basically anything that's not on the orange list. You can argue that there are no doubts and therefore should not be disclosed. The ICC does not do that. So it seems to be this very strict standard that is based on something that's very difficult to pinpoint, namely doubts, without any kind of guidance whatsoever. And of course, the ICC is very careful not to refer to the IBA guidelines on conflict of interest. So I think you can't by default assume that you can just go to the green list. I mean, we all know that, for instance, when it comes to the 3-year deadline that the IBA guidelines set out, you've been appointed within the last 3 years, or you've been appointed 3 times within the last 3 years, the ICC applies a stricter rule than the 3 years. But we're just kind of supposed to know that, and it doesn't really say. And maybe to further the discussion, let me just give you an example of, I think, what we're all experiencing in practice at the moment, and we can maybe discuss on that slightly overdrawn example. I think we're increasingly seeing arbitrators, right, filing these kind of 20-page disclosures, disclosing everything under the sun, dating back 20 years. I attended all these conferences with 200 participants, or a dinner with 50 people, and the arbitrator was there, and I may have shook his hand, but I didn't really have a conversation that was longer than 5 minutes. So what now applies under the new ICC rules, right? So let's assume you're the arbitrator, you make a disclosure, like what I would consider a normal disclosure, so going more or less by the green list. The second arbitrator is appointed and then makes a disclosure, essentially filing her diary, right? This kind of 20-page setting out everything. Obviously, you are then going to be in doubt as to whether you should have done the same thing. So what do? Do you then go back and file your diary as well? Of course, you're then going to risk being challenged for not disclosing it in the first place. Or can you then still, under these new ICC rules, for things that are very clearly on the green list, kind of say, no, I'm holding my ground and I'm making a reasonable disclosure? And what do you do next time you're appointed, right? Do you then go in with your diary, or do you still kind of go by the IBA guidelines? And I think, to me, Lee, that's the problem under the new ICC rules, is that we have this seemingly stricter approach, but no guidelines whatsoever as to what that means, other than under the IBA guidelines. I don't know how you see it.
Well, I actually went looking in the ICC rules to see if there was a reference to the guidelines, and you're right, there wasn't. And then I went looking in the AKICA rules, and the AKICA rules do expressly provide that the arbitrator and the parties and AKICA should have regard to the IBA guidelines. I thought that was interesting, and so that clarification might be required from the ICC. I think if the rule is construed as requiring arbitrators to over-disclose, if you like, I think that's going to be quite a burden on arbitrators, but it also potentially increases the risk of challenge, because parties have more opportunity to seize on a disclosure or a combination of disclosures, however trivial, to grant a legal challenge. So I think that's a risk.
And how does all of this play into the currently applicable system in Australia? Is it compatible?
So in Australia, so our legislation, it replicates the model law, but there's clarification in the legislation as to when there are justifiable doubts. So the test derives from the English law system. Justifiable doubts only arise where there is a real danger of bias on the part of the arbitrator or prospective arbitrator. So that was inserted into the legislation in about 2010. So it requires a real danger of actual bias, and that's the same test at the disclosure and the challenge stage. So like the model law, an arbitrator must disclose circumstances likely to give rise to justifiable doubts, but to be successful, a challenge requires the actual existence of circumstances giving rise to those doubts. So just one more question I had on the ICC rules, if I could, is what you thought of the new obligation on the parties to assist the arbitrator, if you like, in its research. Do you think that will contribute to a new norm of over-disclosure?
I'm not sure it will. What I can tell you is that I'm getting very excited calls from my clients, basically going, what the hell is this? And why do we have to do this? And what do we need to do to amend our contracts to get our ICC clauses out of our contracts and agree on something else? Because of course, they hate anything that's a burden on them, and that means that they have to, in a very stressful time, often when you're putting together a request for arbitration or an answer to the request for arbitration, kind of putting together this list of potentially third parties. And of course, the fear is, well, it has to be over complete, because if we miss something or someone, then we're waiving a right that we may have otherwise had. And they really feel that kind of the burden is being put on them to do something that should not be their job. What I'm trying to explain to them, I'm not sure it's worse than what we have now, right? Because what you have now is basically a junior member of the Secretariat going through the documents and basically just compiling a list with any name that appears anywhere in any contract or any document, no matter how irrelevant it is, which is then creating an obligation on the arbitrators to kind of run conflicts with regard to all of these. They call them third parties or related parties, I can't remember, which, without knowing what the role of those third parties is. And we all know that, very often half of them are completely and utterly irrelevant. So I'm not sure whether putting this additional burden on the parties to actually come up with these third parties that may be relevant might not end up being a good thing. So that's probably the one change that might be more positive about than others. I don't know. What do you think about it?
I think if there's a pro, it probably reduces. I would suggest it would reduce the risk of more late challenges late in the piece. Do you think over disclosure is worse than under disclosure? Are you advocating for under disclosure?
It's a good question, right? And I mean, all of this is, of course, under the theme of we want transparency in arbitration, and it should all be out there, and it should all be out in the open. And it's hard to argue with that, right? Obviously, the parties should be in a position to know what's going on if there are really issues that may, in my view, not subjectively, but objectively call into doubt an arbitrator's independence or impartiality. So absolutely nothing to be said against that. My problem is more with the lack of guidance in combination with this practice that is creeping up on us. So I think what I like about the IBA system is it provides that transparency, but it also sets clear guidelines and boundaries to that, which, if applied correctly, should lead to a situation where no one's filing their diary from the last 20 years, right? The problem is we have these other institutional rules that are encouraging that and that are kind of blurring the lines. And I think we may, depending on how the ICC applies this, end up in a situation under these new IBA rules where kind of the worst of all worlds are coming together. So this relatively broad standard without any kind of guidance. No one knows whether the IBA green list has any relevance at all. And no one's going to know what to do. And everyone's going to be so afraid that they're going to be over disclosing. And that's where I see a problem, because I don't think that is in the interest of the parties, right? Because it is going to create additional challenges. You can say 100 times in your rules that a disclosure doesn't mean that you can successfully challenge, but it's still going to raise ideas in the parties. And we all know that, if anything, parties are becoming more and more combative. So I would be very surprised if we didn't see more challenges in the next years. But maybe that's just me. I don't know how you see it.
I mean, I agree that that second clarification, disclosure alone is not evidence of a conflict. I don't think that mitigates the risk of over disclosure. I don't think it achieves that if that's what is intended to achieve. I've often wondered, I don't really have a satisfactory answer, but I've often wondered what is the rationale for the gap between disclosure and disqualification? Why must arbitrators disclose circumstances that do not give rise to doubts? Does the gap make sense to you?
A good one. In the IBA system, I'm not saying I agree with it, but it kind of at least makes sense, right? Because they are very specifically saying we have two different standards that apply to disclosure versus a challenge, so versus an actual conflict. We have a subjective one that applies to disclosure. So whatever could cause justifiable doubts in the parties from the parties' subjective perspective, which they say is broader than then what actually creates justifiable doubts in the eyes of a reasonable third party, which is arguably a less strict approach, an objective approach. And if you accept that as a system, then I think the statement that not every disclosure means a successful challenge makes sense, right? Because it's two different standards that apply. And this is where, for me, under the ICC rules, it doesn't really work because, first of all, I still have not really understood what the standard is under the ICC rules. I think they say it for disclosure, they say it's an objective standard, although at least for impartiality, the rules also refer to the eyes of the parties, which is the same language as the IBA guidelines, which say that it's subjective. But assuming it's an objective standard for disclosure, and then it's also an objective standard for then actually finding that there is a conflict and accepting a challenge, where is then the delta where you can say that not every disclosure means a successful challenge? There seems to be very little room in between then for that clarifying sentence. So I'm frankly not quite sure I understand the system. I don't know about you.
Okay. Maybe we could see if others on the call want to proffer a view.
Sure. Indeed. Thank you so much for helping us to navigate these changes and also the existing system of disclosures, which raises a lot of food for thought. Do we have questions or comments from those on the line? I have one question in the meantime while we get our audience warmed up is if we're in a sort of ideal world where the IBA guidelines are a harmonized or predictable framework from which to reference ourselves for disclosures. But we've already seen in some of those decisions that you outlined, Chris, that the application or the enforcement of those standards is also inconsistent. What can we do to achieve predictability and consistency in this area across all these jurisdictions?
I mean, what do we do in other areas, right? We train judges, and I think that's something we could do here too. The problem is, it's of course difficult to train judges when we can't agree on the rules. So I think we need to first agree on the rules, and if we can all agree what the rules are, then I think we can go out and like ICA does for many other things, especially enforcement, train judges and say, we have these IBA guidelines, this is what applies, this is kind of accepted by the international community. You're always going to have outlier jurisdictions, as you do with everything, but at least we could try to harmonize it. I think at the moment, we're not even really trying to harmonize.
Can I jump in here? This is one of my favorite topics, and I know we've only got 4 minutes, so I'll be quick. I actually think, the IBA rules, I think, have not clarified the situation at all. But I've thought about this a lot. I really think it comes down to where are arbitrators sitting the most and what have they learnt about what's acceptable as disclosure. And I'm speaking largely from Hong Kong, and I hate to say this in a public forum, but I do think these kind of enhancements of rules, whether they're enhancements is a question, it's going to lead to potential arbitrators having different approaches to disclosure, depending on which institution it is and who's involved, which is not the aim of this at all, in my opinion. I do think there needs to be more objectivity in this, but I actually don't think it's possible the way arbitral institutions are set up. And I mean, for me, just as an example, if I'm in Hong Kong seat, HKIAC rules, obviously I have a good idea of how things run at the HKIAC and what their kind of standards are. Of course, if you're thinking about something you're conflicted, you must make a disclosure. But all of that grey area, so orange going to green, where you're not quite sure, especially in a community where everyone knows each other, and you will have met someone at a cocktail and had more than a 5-minute conversation with them. In Hong Kong, I probably wouldn't disclose that, everything else being equal. At the ICC, based on what you said right now, I probably should. And this is precisely what we don't want to happen, but I don't see another way out of it.
Exactly. Other thoughts from those on the line?
If not, maybe just one more point just to throw out there and see if anyone has a reaction. I mean, I'm increasingly seeing these kind of boilerplatey standard disclosures, things like I regularly attend arbitration conferences and dinners and meet different people and speak to them and shake their hands. And I'm also a member of professional organizations. I mean, is this really helpful? And are we complying with any disclosure obligations by doing that? Has anyone seen something like that challenged?
No, but I think it maybe not so boilerplate is very hard to even ask for further details. I have seen follow-up questions where it may have identified people or places or particular professional associations, but I agree that the complete boilerplate catch-all it doesn't give a lot to work with.
I feel like, sorry, I pressed the wrong button and exited the meeting before. I feel like arbitrators need to get a bit more robust on this as well. And if that means you may lose a challenge occasionally, I think that's part of it, because it cannot be the sort of ICDR, sorry, this is my impression, it may be wrong, style disclosure, where, to Chris's point before, I've seen those disclosures. I spoke to someone at ICA for 5 minutes, and that is a disclosure they are making, and there is no other relationship between these two individuals. I think it's insane. I don't see how the arbitration world can progress, and then you lose sight of what the real conflicts are and what the real problems are, where you've got a close personal relationship, or what I'm seeing in Hong Kong at the moment, the Hong Kong bars having a bit of a run of it because of the way the junior senior relationships are structured, and whether that is actually a situation of influence or not. But there's so many things, but I think the green list is just such dangerous territory.
And the more we're seeing that, the more we're in doubt every time we need to make a disclosure, right?